Hello. Welcome to our YouTube channel. If you are new here, please subscribe. This is another video presentation featuring a question on corporation law asked in the 2019 bar exams. The question was, in 2016, X Corporation obtained a loan worth 50 million pesos from J Bank, which was secured by a third-party mortgage executed by Y, Incorporated in favor of X Corporation. Since X Corporation was not able to settle its loan obligation to J Bank when it fell due, and despite numerous demands, J Bank foreclosed the mortgaged properties. The properties were sold in a foreclosure sale for 35 million pesos, thereby leaving a 15 million pesos deficiency. For failure of X Corporation to pay said deficiency, J Bank filed a complaint for sum of money against X Corporation, its president, Mr. P, and Y Incorporated. With respect to Mr. P, J Bank argued that he should be held solidarily liable together with X Corporation because he signed the loan document on behalf of X Corporation in his capacity as president. On the other hand, J Bank contended that Y Incorporated should also be held solidarily liable because the shareholdings of both corporations are identically owned and their operations are controlled by the same people, hence, Y Incorporated is a mere alter ego of X Corporation. A. Should Mr. P be held liable? Explain. B. Should Y Incorporated be held liable? Explain. This is another question on the doctrine of separate juridical personality and the related doctrine of piercing the veil of corporate entity and the principle of limited liability. It would be ideal for the examinand to showcase his or her knowledge on how to properly apply these doctrines. The key to properly answer problem-type questions is to properly identify the relevant facts. There are occasions also that identifying the arguments is also key, such as in this case. These are the relevant facts. 1. X Corporation obtained a loan worth 50 million pesos from J Bank. 2. The loan was secured a third-party mortgage executed by Y Incorporated. 3. J Bank foreclosed the mortgage when X Corporation failed to pay. 4. J Bank sued X Corporation, its president, Mr. P, and Y Incorporated to collect the deficiency. The argument against Mr. P. He should be held solidarily liable because he signed the loan document on behalf of X Corporation. The argument against Y Incorporated. Y Incorporated should also be held solidarily liable because Y Incorporated is a mere alter ego of X Corporation. Obviously, the bank is invoking the doctrine of piercing the corporate veil. Piercing the veil of corporate entity is an equitable remedy. It is resorted to when the corporate fiction is used to defeat public convenience, justify wrong, protect fraud or defend a crime. It is done only when a corporation is a mere alter ego or business conduit of a person or another corporation. The question is, will you apply the doctrine to Mr. P? If not, what will you invoke? The principle of limited liability may be applied to Mr. P. This principle states, the corporate debt is not the debt of the stockholder. Thus, being an officer or a stockholder of a corporation does not make one's property the property also of the corporation. When corporate officers are solidarily liable, a corporate director, trustee, or officer is to be held solidarity liable with the corporation only in the following instances. 1. When directors and trustees or, in appropriate cases, the officers of a corporation, A. Vote for or assent to patently unlawful acts of the corporation, B. Act in bad faith or with gross negligence in directing the corporate affairs, C. Are guilty of conflict of interest to the prejudice of the corporation, its stockholders or members, and other persons. 2. When a director or officer has consented to the issuance of watered stocks or who, having knowledge thereof, did not forthwith file with the corporate secretary his written objection thereto. 3. When a director, trustee or officer has contractually agreed or stipulated to hold himself personally and solidarily liable with the corporation, or 4. When a director, trustee or officer is made, by specific provision of law, personally liable for his corporate action. None of the above instances were shown in the problem. How about why incorporated? Will you apply the doctrine of piercing the veil based on the argument that it is merely an alter ego of X corporation? Three-pronged tests to determine the application of the alter ego theory are 1. Control, not mere majority or complete stock control, but complete domination, not only of finances but of policy and business practice in respect to the transaction attacked, so that the corporate entity as to this transaction have at the time no separate mind, will or existence of its own. 2. Such control must have been used by the defendant to commit fraud or wrong, to perpetuate the violation of a statutory or other positive legal duty, or dishonest and unjust act in contravention of plaintiff's legal right, and 3. The aforesaid control and breach of duty must have proximately caused the injury or unjust loss complained of. In the problem, none of these were shown, as the problem merely states that Y, Incorporated merely acted as a third-party mortgagor in favor of X Corporation. That fact alone will not call for the application of the alter ego principle absent any other facts and circumstances to engender a conclusion that Y, Incorporated is merely an alter ego of X Corporation. The suggested answer to the question is, for question 8, no, Mr. P should not be held solidarily liable with the corporation because the principle of limited liability applies to him. Under the said principle, the corporate debt is not the debt of the stockholders nor the directors of the corporation. There were also no showing that Mr. P acted in bad faith, with gross negligence, or contractually agreed that to hold himself solidarily liable with the corporation insofar as its liability with X Corporation is concerned. For question B, no, Y, Incorporated should also not be held solidarily liable with the corporation because the alter ego theory in this case is inapplicable. There is nothing in the narration of facts that will justify the application of the doctrine of piercing the corporate veil based on the alter ego principle. Aside from the fact that Y, Incorporated acted as third-party mortgagor in favor of X Corporation, there was no other indication that X Corporation has exercised control over Y, Incorporated, and even if it was narrated that X Corporation exercised control over Y, Incorporated, it would still not be enough because what is required is complete domination, not only of finances but of policy, so that Y, Incorporated will be shown to have no separate mind, will, or existence of its own. We hope you learned something useful in this video. Thank you. If you liked this video, please subscribe to our channel and like our Facebook page ECS Notes. You may also comment and share this video to your friends. Have a pleasant day.